Hi, this section we're going to talk about agency law. And the objectives for this certainly is looking at how the agency relationship works and how authority is created for agents. But we want to look at not just in this aspect, much of the discussion is about players, agents, and representation. However, we want to really extend that and show that in an organization, we could be agents for that organization. Do we have the ability to bind the organization to a contract? If we are doing that, then we are an agent of the organization. We're going to look at the functions, the duties of the agents, and the principles, as well as how athlete agents, and certainly this is much more of a sport specific area, how they are regulated. So by definition, the rights and responsibilities of both principals and agents is agency law. It's the authority of the agent as he or she works for the principal and the creation of the agency relationship as well. So we look at these different ideas of how the agent, what they're allowed to do, what they are not allowed to do, what the principal is allowed to do and what they're not allowed to do, and how we create this agency relationship. Um, Agency law governs the relationship between the principal, the organization, or the representative, or the agent, as a legal relationship exists to the business function. So, how do we create this idea, or how do we create this ability to bind the organization? So, some roles of sport agents or agents in the sport world. We can negotiate employment contracts. If you're hiring somebody for an organization, you have become an agent of that organization. If you work for a Dick's Sporting Goods as an assistant manager and you hire an employee, you are now creating a contractual relationship between that employee and the organization. The organization is going to pay this person. This organization provide some training, some perhaps some insurance. The employee is going to give hours and their knowledge and their ability and their experience. So we're creating this contractual relationship between the organization and that person. Therefore, we are an agent. We look at concessions. We look at organizations with sponsors, advertisers. We look at other types of contracts that run events, estate financial planning and investments. We look at a whole lot of different interactions between an agent and the principal. So it's not simply limited to an athlete representation area, although many of our cases will show that. It also is much more in terms of a personal relationship that we have with our organization. How do we create this relationship? Generally, no formality is required. However, as we looked at other contract situations, a formal agreement is much more preferred. So the agent and principal must agree to be a part of a relationship. It should be oral or express, oral or written, which is an express agency relationship. And both parties must have the legal capacity. And we'll get into the legal capacity in a little bit. Certainly, you have to be of age. You can't have any incapacitation. We can form this agency by an agreement, by a contract, by ratification, which means the principal accepts the acts of the person who has no authority. And we'll look at authority in a minute. But basically, this means that the agent doesn't have the authority or the ability to do some sort of action. They do that action, and the principal then ratifies it. The principal agrees to it and allows that to continue. We'll also look at agency by estoppel, or this apparent authority, where a third party reasonably believes an agency relationship exists between an agent and a principal where it doesn't, and they rely on that assumption. In many points, if it continues, then a court may allow that relationship to continue and say it's created by estoppel or an apparent authority, that the third person reasonably relied on the fact that there is a relationship there when in fact there wasn't. So we'll look at the LA Rams versus Canon aspect of a contract formation and how perhaps now with agents advising players that this case will turn out very differently. Authority is the power to bind a principal or to have a principal liable for the acts of the agent. We'll look at the actual authority, applied authority, and that apparent authority I talked about a second ago. Actual authority, an express authority, authority specifically granted in an agency agreement, your job description, your contract, your employment contract that states exactly what your authority is. By being an assistant manager, you have the authority to hire and fire employees. Okay, great. You can have the implied authority, authority that's reasonably necessary to carry out express authority. So perhaps you don't have that within your agreement, but if you're running a Dick's Sporting Goods, it's implied that you have the authority to negotiate contracts to hire employees, that you may have an implied authority to travel, to see clients, to make sales pitches. So there's some implied authority that goes in with the position, as well as actual authority that's specifically laid out in your employment contract or in another agency agreement that dictates what that relationship is. Apparent authority is this idea of estoppel, that a third party reasonably believes incorrectly that an agent is acting with actual authority, that the principal is then held liable even though no actual authority was given. There's a case that bears this out where a sponsor was talking to a potential sponsor was talking to a property. So a property is discussing sponsorship agreement with a potential client, and at that meeting for the sponsor organization, there was a vice president as well as the president of the company. The president leaves to go catch an early flight, leaving the vice president and the property to continue negotiations. They came to an agreement. The president later looked at it and said, I didn't agree to this, so there should be no agreement after they signed the contract. The court upheld it because the third party reasonably had expectations that an agreement, or that the vice president had that authority to enter into agreement. Because you had this idea that I'm talking with a person and the president's there and the president leaves and allows it to continue on. So the third party shouldn't have a detriment to it that this authority didn't exist. So this is estoppel, apparent authority, that based on the circumstances, it appeared as though that agent had the authority to enter into agreement when in fact they hadn't. But in this case, we're going to hold the principal liable anyway. Here's another example. The manager or an agent of a sporting goods store, the principal, has actual authority to make contracts up to a value of $15,000. This actual authority has been conveyed in writing to the manager. The manager, however, has entered into several transactions with vendors for amounts in excess of $15,000 in the past, and the store owners have taken no action against the manager for violating his actual authority. The manager purchased equipment for $25,000 from a vendor with whom he has exceeded $15,000 limit before. The store owners now want to void the agreement. So the third-party vendor could argue that the store owners should be bound by that agreement because they violated the actual authority in the past, that this vendor for $25,000 is seeing the authority of the manager and assuming that they have the actual authority to bind the principal to $25,000. Ratification occurs when the agent acts without authority and the doctrine of apparent authority does not apply. The principal is generally not legally bound by the agent's acts. However, the principal may affirm the acts performed by the agent who lacked authority. Then those acts are legally binding for the principal as if the agent acted with actual authority in the first place. In order to be ratified, an agent's actions must be those that the principal can delegate and the agent can perform. So we look at duties, responsibilities from both the agent to the principal, as well as the principal to the agent. Duty from the agent to the principal, the responsibilities an agent has to the principal. A fiduciary duty. The agent must act for the benefit of the principal, even if it goes against the best interest of the agent. For instance, if you have a fiduciary duty with a real estate agent and you are looking to buy a house, it is in the best interest of the real estate agent to have that purchase price be as high as possible. They're making a commission on it. However, the fiduciary duty to the client or the purchaser is to get the price as low as possible. Part of this fiduciary duty, an agent cannot engage in double dealing. In other words, working for the principal and a third party. You can't take personal advantage of business opportunities. So the fiduciary duties, you have a duty of loyalty, where you act solely and completely for the principal. You have a duty of obedience, where you follow all reasonable instruction. And you have a duty to avoid conflicts of interest, that you need to be at least make the people aware of the fact that there's conflict that exists. And if any of them does not like it, that you have to give up the conflict. We'll look at Zinn versus Parrish. We'll look at Detroit Lions versus Argovitz. There's a duty that the principal or the organization owes to the agent or the employees, a duty of fair compensation, a duty to reimburse expenses, a duty to indemnify any personal losses, and a duty of overall good conduct. Those are duties that the principal owes the agent, that the organization owes the employee. We'll look at Brown versus Wolf. So we look at this idea for liability, which is a certain aspect of this contracts. Under contract law, lawsuits can often arise in which a court must determine who is liable for the performance of the contract. Is the principal liable? Is the agent liable? Or would both parties be liable? So when you look at in a contract situation, the key is whether the agent is within their authority, the authority to bind the principal to a contract. If the agent is within that authority, the principal is liable for the contract. So if I have actual authority, or if I have the implied authority, or if it's been ratified, or if I have estoppel or that apparent authority, the principal is liable for the contract. If the agent is not liable, unless the agent acts for undisclosed reasons or partially disclosed, then the agent wouldn't be liable. So, in other words, an agent may be liable for a contract itself if the agent acts for an undisclosed principal, meaning if I'm representing a client who is either completely disclosed where the person I'm negotiating has no idea I'm representing somebody, or if it's partially disclosed, which means I'm negotiating with somebody and they know I'm representing somebody, but they don't know who that person is, then the agent may be reliable for the contract. Think about it from this side. If you're negotiating with somebody, you don't know that they're representing somebody. So you're negotiating with a person right in front of you. You can decide whether or not you want that person to enter an agreement with you. It doesn't matter if they're representing somebody else. I'm making the agreement in my perception with this person. So they should be liable. If they're partially liable and I still don't know who they're representing, they still need to be liable for the contract. I should not be out of the terms of the contract because of this relationship that the person may have. If apparent authority is present, if that estoppel is present, the principal is liable and so is the agent. Again, as a double protection against the other person to a contract so that they're not out this negotiation. Liability and determination of torts and tort law that we looked at a few weeks ago. Scope of employment is the realm of activities engaged by the agent when acting on behalf of the principal. So if you're within the scope of employment, the employer or the principal is liable for the negligent acts. Respondeat superior says a legal doctrine that holds people and organizations in the chain of command liable for the negligent act for those who are lower. So we see this idea again that from an uncompensated personnel, that if you're within the scope of employment, the employer or the principal is liable for the acts of the employees. Some factors to analyze whether if it's in the scope of employment. Did the agent commit the act that was authorized by the principal? What was the time, place, and purpose of the act? If that is within the scope of employment, if it's on your corporate time and property, it's going to lend itself that it's within that scope of employment. Is it an act commonly performed by employees on behalf of their employers? Whether the employer's interest was enhanced by the act. The extent of the involvement of the employee's private interest, whether the employer furnished the means by which the injury was inflicted, whether the employer had reason to know the employee would perform the act in question. So those are factors that we'll look at to decide, is the employee working in the scope of employment or are they frolicking in their own affairs? If they're within the scope of employment, then the employer will be liable for the tort actions of their employees. If they're not within the scope of employment, then they're not liable. We're going to look at the regulation of athlete agents, and this is much more of a sport-specific topic than probably we've looked at in the past. The reason why we look at regulation is this need of athlete abuses and agent abuses in the past. It's had a negative impact on athletes, on colleges, on universities. Athletes have lost money, they've lost eligibility, colleges have lost different things. And the reason why we had this regulation come out is the fact that in the past before, we'd have a negative action, maybe an athlete agent signs a player to an eligibility contract, thus they lose the ability to play for their team, yet the agent hasn't done anything illegal. That we'd have the player lose eligibility, we'd have the school lose wins and potential income, yet out of all this, nothing happened to the agent. So we're looking at this idea as we're moving forward that regulation of athlete agents, one thing that we can regulate is a state law, a very specific state law. So states can create their own laws that says you cannot violate some sort of behavior. In fact, many have gone and adopted this Uniform Athlete Agents Act. 40 states have this act that's been adopted. A few more than the 40 states have their own state law that provides similar actions. So we look at this idea. The UAAA, the Uniform Athlete Agent Act, a state law, provides for the uniformity of registration and certification of athletes' agents among the states. It provides that agents who sign contracts with student athletes must provide notice to the particular university and must make clear to the student athletes that their eligibility is affected. Notice must be given in the contract. In other words, if you're going to sign a student athlete to a contract to represent them, this state law and this Uniform Athlete Agent Act has specific requirements that the student athlete must know that their eligibility will be affected, and the state universities and the colleges must know that they can't play these players anymore. It provides for uniformity in registration certification. Most states have a particular registration process that in order to be an athlete agent in their state, they need to fill out some paperwork. This Uniform Athlete Agent Act allows you to have the same paperwork in these 40 different states. Here's an example of states in red. They're the ones that have adopted the UAAA. 3 more have other state law that's a part of it, just not the Uniform Athlete Agents Act. So many of the states are regulating via a state law of agents. We also see federal law, the Sport Agent Responsibility and Trust Act. This federal law prohibits agents from making false or misleading promises or providing gifts, cash to student athletes and those associated with student athletes. And it's similar to the Uniform Athlete Agents Act. SPARTA requires written disclosures informing students that they could lose their eligibility to play university sports if they sign an agency contract. There's no registration required for SPARTA. So if anyone begins negotiating or trying to sign a student athlete, they are automatically covered under the Sport Agents Responsibility and Trust Act. That's a federal law. The UAAA is a state law. And we'll look at U.S. versus Walters. That really shows the reasons why. And Piggy, that shows the reasons why we need this type of law. We also see regulation coming from the professional leagues, that each of the Players Association, as the union of the players, require some sort of registration. Standards vary. There could be an exam, there could be paying money, there can just be notification. However, if you want to represent any player within the union, you have to be registered with the Players Association. No law degree is required to be an athlete registration, and your registration with the union may be specifically approved, or it may be revoked depending on how your behavior is. State bar associations. If the agent is a lawyer, they have to be a member of the state bar. So if they violate ethical rules or violate the law, they could be disbarred from their organization and lose their law license. So we look at state law, we look at federal law, we look at registration with the Players Association, and we look at state bar associations as four main ways that we look at regulation of athlete agents. Finally, we'll look at this idea of disputes, and we'll look at the breach of contract and also look at some of the tort law issues when we flesh out this relationship of these athlete agents. Lamont Smith versus Condon will dictate this, and we also see one that we'll discuss with the Lee Steinberg case as they pulled out and reorganized their partnership. So I hope that this discussion and these cases, once we flesh this topic out, has really created some visibility and appreciation for the idea of agency law. And I just want to very clear once again that this isn't solely a sport agent, an athlete representation law or topic, although at the very end those specific regulations did confine to that narrow aspect. But the agency law really governs all of us as employees and as employers.